Good morning, this is your Kelso Report for Thursday, March 28th. I'm your host, Clark Kelso. We start with two Supreme Court decisions today, the first involving the Federal Tort Claims Act and the second involving class action certification in an antitrust lawsuit. The Ninth Circuit has a decision dealing with appellate jurisdiction, and we close with an arbitration decision from the California Court of Appeal. The Federal Tort Claims Act waives the sovereign immunity of the United States with respect to certain common torts, such as negligence, but generally does not waive immunity for intentional torts. However, there is a special exception for certain intentional torts, such as assault and battery, committed by law enforcement officers. In Millbrook v. United States, the question was whether the waiver applied when the intentional tort did not occur in the course of investigative activities, such as executing a search, seizing evidence, or making an arrest. In Millbrook, the plaintiff alleged that correctional officers sexually assaulted and verbally threatened him while he was in their custody. The United States argued that this activity was not in the course of a search, seizure, or arrest, and that the waiver of sovereign immunity therefore did not apply. The Supreme Court unanimously disagreed based on the plain meaning of the statute, which simply waives immunity for certain torts with respect to, quote, federal law enforcement officers, close quote. The language is based upon the status of the tortfeasor as a federal employee and a federal law enforcement officer. There's nothing suggesting that the provision should be limited only to torts committed in the course of certain types of law enforcement activities. So accordingly, as long as the officers were acting within the scope of their employment, the general rule under the Federal Tort Claims Act, the waiver for intentional torts by federal law enforcement officers applies. Next, an antitrust decision involving class actions. Now, I have noted at various times recently that the current Supreme Court does not always break out into customary divisions of conservative versus liberal or Democratic versus Republican appointees. But there is nothing like some basic economic theory, as embodied in the antitrust laws, to bring out the justices' core philosophies. And so it is mildly refreshing to see a 5-4 split along the traditional ideological divide in Comcast Corp. Versus Barron, which involves class action requirements in a Section 1 and Section 2 case alleging anti-competitive and monopolistic practices in the cable television business. In particular, the complaint alleged that Comcast had engaged in a clustering strategy within several large designated markets. Pursuant to this strategy, Comcast would acquire a competitor cable provider and swap their own systems outside that region for the competitor systems located in the region. In Philadelphia, for example, as a result of 9 clustering transactions over an 8-year period, Comcast's share of the market grew from 24% to 70%. The question before the court was whether the district court correctly certified a class under Rule 23b-3. The conservative majority on the court held that the class should not have been certified because there was no showing that the measure of damages was a common question for class members. The district court had accepted only one theory of antitrust damages in the case, namely that the clustering practice reduced competition from so-called overbuilders who build competing cable networks in areas where an incumbent cable company already operates. Well, unfortunately for plaintiffs, their expert on damages did not produce a damage model limited to that one theory of damages. Instead, he produced a model that incorporated damages from 3 additional theories, none of which had been accepted by the district court. As a result, there was no damage model which matched the theory of antitrust injury in the case, and the majority held that it was then error to certify a class where there was no accepted class-wide theory of damages. Next, we turn to an appellate jurisdiction decision from the Ninth Circuit. Originally developed in the antitrust context, the Norr-Pennington Doctrine is intended to protect the First Amendment right to petition government by creating an immunity from federal statutory liability for petitioning activity. It is a federal immunity similar in some respects to California's state anti-SLAPP statute, which creates an expedited process for evaluating whether a claim that arises out of First Amendment protected activity is likely to succeed on the merits. Well, in Tenedo versus East Baton Rouge Parish School Board, the Ninth Circuit faced a case in which the defendant's effort to invoke Norr-Pennington immunity was denied by the district court, and the defendant sought to immediately appeal that ruling, arguing that his First Amendment rights could be protected only by an immediate appeal. But, as we all know, appeals in the federal system are governed generally by the final judgment rule, which has only narrow exceptions for certain collateral orders. The Ninth Circuit held that a denial of Norr-Pennington immunity is not a collateral order that is immediately appealable, since the applicability of the immunity is often intertwined with the underlying merits and is therefore not collateral. And, for similar reasons, a denial of Norr-Pennington immunity is one that can be reviewed on appeal from a final judgment. So the defendant's just going to have to wait. Finally, arbitration. Now, it's been a while since we've seen a state court opinion dealing with the enforceability of an arbitration clause. As you know, California state courts have often been pretty hostile to arbitration clauses in consumer contracts, notwithstanding rather routine statements by the United States Supreme Court that such agreements are generally enforceable under federal law. It appears that at least one California Intermediate Appellate Court has finally gotten the message. In Vasquez versus Green Motors, the First District faced a standard arbitration clause that was printed on the back of a used car sales agreement. The Superior Court had refused the dealer's demand for arbitration, holding that the clause was unconscionable. Well, the First District reversed. It agreed that the arbitration clause was adhesive and procedurally unconscionable because there was no opportunity for negotiation and it was on the back of a pre-printed form. But the court found nothing about the clause that was substantively unconscionable. The clause applied equally to both parties and did not have any of the one-sidedness that would have marked the clause as substantively unfair. Since the clause was not substantively unconscionable, the First District concluded that the clause overall was enforceable and the parties are off to arbitration. And that's it for today's Kelso Report. Have a great day in the law.